All right, let's discuss some of the struggles from chapter one. This first picture is of Minnie Fisher Cunningham. A lot of times she was called Minnie Fish. Um, she worked on Lyndon Baines Johnson's in his cabinet and was one of the primary advocates for women getting the right to vote in the state. If you have taken American government or American history, you will know that the women's suffrage movement um, and women's rights movement was really, really closely aligned with the abolitionist movement and eventually the civil rights movement. I have not been able to find any indication that the women's suffrage movement in Texas was tied to uh, civil rights. And certainly at the time when Minnie Fisher Cunningham was working to get women the right to vote. And she was a pharmacist, finished pharmacy school, couldn't get a job, um, super smart but at the time there was some friction between um, the civil rights movement, primarily for African Americans, and the women's movement, because a lot of people were really upset that when the 15th Amendment to the United States Constitution was written, it did not include women, even though women had worked really hard along with the abolitionist movement. So I have not seen any indication that the two were involved. If we examine the women's movement, the women's suffrage movement in Texas, I can tell you two things. Thanks in no small part to the lobbying efforts of Minnie Fisher Cunningham and to women that were working with the movement, Texas gave women the right to vote prior to the 19th Amendment being passed. The 19th Amendment was ratified by the final state in 1920. Women were able to vote in Texas in 1918. And as they started rolling out the newly approved 19th Amendment, Texas was the first southern state to actually give women the right to vote. So a little ahead of its time for southern states. And a lot of that, the way was paved by women suffragists like Minnie Fish. Let's talk about the struggle for equal rights for African Americans. So, Texas was one of the states that seceded from the Union and became part of the Confederate States of America. Now, I have heard arguments that the reason that states seceded was for because of states' rights. It had nothing to do with slavery. But you've watched Remembering the Alamo. Um, and I am going to tell you, and I will show you at a later time, the um, Declaration of Causes that was written by the legislature of the state of Texas when they decided to secede. And when they were seceding, they said that they were doing so because the United States government wasn't recognizing the beauty and the authority of slavery, and that they were trying to put the Negro, as they refer to it in that document, and whites on the same plane, and that was against nature. So Texas seceded because of slavery. And as time progressed, so you had that institution that was ingrained. You had people that were deathly afraid of the changes that were happening in the United States and in their state. Um, and you are able to see some of the issues that African Americans had to deal with. Let's talk about some of them. One was in Texas for years. Texas had what was called the white only primary, the white primary. That law, it was part of the Texas Constitution that said that only whites could vote in primaries. Now, primary is when you decide who is going to be the candidate from your party. After the Civil War, everybody was a Democrat. All the people in power were Democrats. Um, and so um, at first, the state of Texas said that no person of color could vote in any primary. Um, the case of Nixon versus Herndon, no case. No, I love cases. Nixon versus Herndon was the case when the Supreme Court told Texas that their law was unconstitutional. It was actually a violation of the 14th Amendment to have a state law that made distinctions based on race. So, not to be undone, the Texas Democratic Party decided that, okay, well, you just can't vote in Democratic primary because we're not a part of the state. We are a separate entity. And so you just can't vote in Democratic primaries, which was really the same thing because everybody that was in power was a part of the Democratic Party. You know, Abraham Lincoln was a Republican. So, Republican was a bad word in the state of Texas. So the Democratic Party started saying, you're not going to be able to determine who is actually going to get the position because you won't be able to vote in the Democratic primary, which we, private entity, are conducting. It wasn't until 1944 when the case finally made it to the Supreme Court, the Smith versus Allwright case, when the Supreme Court said, listen, when you are conducting primaries, you are acting in a governmental entity. So it is no different than the state of Texas saying that people of color could not participate in primaries. And they finally knocked that down and considered the white only primary conducted by the Democratic Party to be unconstitutional as well. The white supremacist movement was very well organized. There were several organizations, but probably the most prominent of them was the Ku Klux Klan, formed to intimidate, formed to make sure that people of color did not advance. Um, in many instances, the KKK was just as active against Latinos in the state of Texas as they were against African American Texans. I left it in there. They were calling them African Texans in the book, and nah. But they were working to keep Texas segregated and to promote white supremacy. That was the stated purpose of the Ku Klux Klan. And it was very strong, very well organized in the state. One organization that was that made its way to the state of Texas. It was formed in the North and had been more active in the North for years. Was the National Association for the Advancement of Colored People. The NAACP. The NAACP is still a thriving organization. But one of the things that they did was took on discrimination in around the country, but we're talking about the state of Texas, by filing suit and challenging either compliance with current laws or the constitutionality of laws. So the NAACP used the court system to combat discrimination. One such case in Texas was the case of Sweat versus Painter. In this case, Thurgood Marshall, who would eventually become one of the justices on the Supreme Court of the United States, Chadwick Boseman played Thurgood Marshall in his early years in a movie called Marshall. He actually took the case of Sweat versus Painter to the United States Supreme Court. He was in front of the Supreme Court all the time. He was the chief attorney for the NAACP, Legal Defense and Education Fund. That was the part of the NAACP that looked for cases, sometimes would even create situations. I certainly think that that was the case in the Sweat versus Painter case. Mr. Sweat wasn't really trying to go to law school, but he was challenging the law of the land, the common law, meaning judge-made law, that was called separate but equal. And so there had been a series of cases where the law said that if you had, it was fine to have segregated schools as long as the facilities were equal. So you could have a white-only elementary as long as you had a black-only elementary. And the question was, were they equal? Now, in Mr. Sweat's case, Texas didn't have a law school for black people. And so he took all the tests and applied to University of Texas Law School. And of course, they told him, no, sir, you cannot come here. There had been a couple of cases where state schools had been ordered to allow African Americans to come in because they didn't have separate facilities. So the University of Texas hurriedly tried to form a law school. And that law school is actually still open. It is a part of Texas State University, TSU, in Houston. Mr. Sweat was from Houston. They placed this newly formed law school in a basement, hired 2 teachers, and said, here you go, Mr. Sweat. We've got a law school for you, got a separate law school. And Mr. Sweat said, that's not equal. And that was the basis of the case being taken to the Supreme Court, that the state of Texas was not obeying the existing separate but equal doctrine. So, and the court agreed, and the court said that Mr. Sweat would be able to go to University of Texas Law School. He was the first African American to do so. This case was combined with a case in Oklahoma where they actually sued University of Oklahoma for a gentleman that was wanting to go to grad school, and they didn't have grad programs for African Americans. So they were like, if it's not equal, you can't You can't force them to go there. So Mr. Sweat goes to University of Texas Law School, stayed for almost a year, dropped out, and then went to pharmacy school and was a pharmacist for years. After the success, now this was of course not a Texas case, but after the success that they were seeing in graduate schools, the NAACP and Thurgood Marshall took the fight to lower schools, and in 1954 the Supreme Court heard the Brown versus Board of Education of Topeka, Kansas case, and ordered that all lower schools, secondary schools, also segregate with all deliberate speed. So this was in 1954. In 1956, and this was the way that it worked. If you were an African American family and you did not think that the school that you were going to was going to work, you would have to file suit against the school district and get an order that would allow the school or order the school to desegregate. Mansfield, and this is Texas government, we are talking Mansfield, Texas, where I am sitting right now, Mansfield, Texas. Actually, a group of families filed suit through the NAACP. The attorney for the NAACP in Tarrant County was a guy named Clifford Davis. Mr. Davis is still alive. And they filed suit because Mansfield did not even have a high school for African Americans. If you lived in Mansfield, you had to get to Fort Worth to go to one of the segregated schools in Fort Worth. I am Terrell. I'm not sure when Dunbar started, but I am Terrell, I know for sure. Um, so the principal, and they won, and they got an order that you can go to Mansfield schools. So the principal at Mansfield High School said, okay, I tell you what, y'all come and register for classes on this date at this time. Everybody has to come together. And then he announced to the community the date and time that the African American students would be coming to enroll. So when the students arrived at Mansfield High School, they were met by a crowd. We called this the Mansfield riots. This was in 1956. The NAACP solicited help from the federal government. That help did not come. Those students never made it inside of Mansfield High School. The parents were in an uproar. They screamed, they hollered, they burned crosses, they hung black dolls by their neck by nooses to make a point. They were not having it. And the Texas Rangers came to Mansfield to help the crowds of people that were trying to keep the students out. They prevailed. And Mansfield High School did not desegregate until 1965. By my count, that is 9 years later. The official order in Texas that said if your school is not desegregated, you must do it now, did not come until 1970. So Brown versus Board of Education of Topeka, Kansas was 1954. The Mansfield riots was 1956. And the order saying, okay, y'all, desegregate was not until 1970. So African Americans have had their share of troubles with systemic, written down, de jure law that was meant and designed to discriminate. The same is true of those of Latin descent. And the book calls Latino Texans. We are primarily talking about in Texas, especially at this time, individuals who had either migrated to Texas from Mexico or who were living in Mexico when Mexico ceded some of their property to the United States. So they were Mexican citizens, then they were American citizens. They hadn't moved at all. They had been here longer than many of the people that were running the state. Some of the issues that we will address are the Raymondville, it's a city, peonage cases. There was in Texas, there was a law that basically said that if you did not have a job, then you were vagrant, or you could be considered to be a vagrant. So they would arrest you for vagrancy, not having a job, and charge you this huge fine, which you probably couldn't pay because you didn't have a job. And they would force you into work to pay off your debts. Or someone would pay the fine for you, and they would then you would go work for them to pay off the debt that they had paid off. In 1929, there was a case that said basically what you are doing is forcing people into slavery. And there is a provision in the Texas Constitution that says that you cannot be imprisoned for debt. That's not in the United States Constitution. That's a uniquely Texas provision. You cannot be imprisoned for debt. So they actually were saying that this is a violation of United States law, Constitution and the Texas Constitution when you are forcing people into work. And they won. They won. Now, what was life like prior to 1950 in Texas for people that were of Mexican descent? The sign, I believe that it was actually in Indiana. I don't think that this was a sign on someplace in Texas, but I just wanted to get a point across that life for people of Mexican descent was difficult and has been difficult for years. This next photo is of Mathis Mexican Ward School. This was a segregated school in the city of Mathis. So this is one shot of this segregated school. It's another shot of the segregated school. This is inside the school. These children are not from Mathis High School, or Mathis, I think that they were from another school, but this is a whole class full of students that were going to Mexican Ward schools. This picture is Mathis High School. The two buildings were on the same property. Now, Mathis High School was for white children only. So just get the picture. Mathis Mexican Ward School, all grades, Mathis High School. So it wasn't that Mathis did not have the money. It was that Mathis did not have the will. And there is no way that anybody could look at that photo and think, well, at least it was equal. This next picture is of a civil rights leader. His name is Hector P. Garcia, actually Dr. Hector P. Garcia. Dr. Garcia formed the American GI Forum. The American GI Forum was actually formed in Corpus Christi. That's where he was from. He had served in the military. He was a medical doctor. And he just noticed that there was widespread discrimination against people of Mexican descent in Texas. So they began to take up causes and file suits and write letters. That's what he did in the case of Felix Longoria. Felix Longoria was a veteran, but when he passed away, they would not allow his family to have a funeral at the cemetery in his town because they didn't want a person of Mexican descent to be seen at the cemetery. So and cemeteries were often segregated. I don't know why it would matter once you're no longer here, but cemeteries were segregated. When I grew up across the street from a cemetery because my little town was segregated, and the cemetery had different parts. African Americans were in the back. You drove down a road, you drove down a path, went through some gates, and then you were in the black section. So I know for a fact that there were segregated cemeteries. The American GI Forum, Dr. Hector P. Garcia wrote a letter to then Senator Lyndon Baines Johnson, and Lyndon Johnson worked with the American GI Forum and actually made sure that Mr. Longoria was interned at the National Cemetery in Arlington, Virginia. Some other things that were very prominent. In 1977, there was a Texas Farm Workers Union march. This was a march from a county in southern Texas, and they were in South Texas, and they were on their way to Austin. The rally or the march, so this is of course several hundred miles. The governor at the time sent the Texas Rangers to go and stop the march before they made it to Austin. Stopped them in San Marcos. And there was some documented violence. The reason that they were marching is because they were requesting a higher minimum wage. You see that? $1.25. This is 1977. So the Texas Rangers stopped them violently. And the group, Dr. Garcia and the American GI Forum, filed suit. And the Supreme Court ended up disbanding the Texas Rangers and saying that the Texas Rangers could no longer be under the direct control of the governor. And to this day, the Texas Rangers are part of the Department of Public Safety. And it was because I've already talked about two incidences. There were several where governors of Texas would use the Texas Rangers to enforce discrimination and would use them to commit violence on behalf of the Texas government. So they had to completely reorganize. And finally, there was the Hernandez versus Texas case. Um, in Hernandez versus Texas, Mr. Hernandez was found guilty of murder, capital murder. Um, and the rule where he was that people of Mexican descent could not serve on juries. So he was convicted by an all-white jury because African Americans couldn't serve either. Um, and he said that that was not a jury of his peers. So this is a United States Constitution Sixth Amendment argument. And the Texas Constitution also affords you a jury of your peers. The Texas government argued that this was not unfair because being of Mexican descent was not a race. There were only three races. They were African Negroid, or Asian Mongoloid, or Caucasoid. And so Mr. Hernandez, they argued, was white. And so, and this case got to the United States Supreme Court in 1954. And so Mr. Hernandez did have a jury of his peers. He was white. The jury was white. What's the problem? Now, the Supreme Court looked at Texas's long history of county laws that wouldn't allow people of Mexican descent to vote, of peonage cases, of segregated schools, and they said, you know what? You apparently think that people of Mexican descent are a different class because you routinely set aside this group of people. So we believe that this should be a protected class because you're treating them, you're discriminating against them. They actually ordered Texas to stop the practice of not allowing Mexican people, Mexican American individuals to serve on juries, and Mr. Hernandez was tried again. Now, I think, if I'm not mistaken, that Mr. Hernandez was convicted again, but it really set the precedent for how things would proceed and this concept of class that we would see again in the Civil Rights Act of 1965. The fight to desegregate schools started in 1948 with the Delgado versus Bastrop ISD case. And so it just kept going, kept going, kept going. You cannot have Mexican ward schools. You cannot have desegregated schools. It was finally settled in 1957 in the Herminca Hernandez versus Driscoll Consolidated ISD. Now, both Bastrop and Driscoll Consolidated, or Driscoll, are outside of Austin. And in that case, the Supreme Court finally said, look, you are going to have to close these schools. You cannot have segregated schools. Now, what a lot of school districts did was close the Mexican ward schools and then sent students that were of Mexican descent to the segregated black schools. Look, we desegregated. There we go. Yay. But you know, that's the way that works. Now I do this all the time. I get started talking about things and then the slide comes up. So here is the details of the Hernandez versus Texas case. This is groundbreaking because again, it established the class system of looking at discrimination. And are you treating a group as a class? Are you discriminating against a group as a class? And this would become the basis of law that is still on the books today. So it is a huge case. Let's talk a little bit about Texas' struggle for equal rights on the lesbian, gay, bisexual, and transgender Texans front. So the case that we're going to discuss, there were cases before it, but the one that we're going to discuss, because it is a Texas case, is called Lawrence versus Texas. It was heard in the 80s. And in this instance, Texas had a law against sodomy. And that's basically a word that comes from Christian origins, talking about the cities of Sodom and Gomorrah, where in the Christian Bible it discusses men that looked upon men, that liked men. So in the Lawrence versus Texas case, this was actually a couple. Certainly they weren't married, but they were a couple. They had a house. They lived in the house. Someone called, a neighbor called the police and said that there was an armed robbery in progress. So the police arrived at their house, and when no one answered the door, they broke in. And they found these gentlemen engaging in the activity that was still illegal in Texas and about 13 other states. And they were charged with violation. Now, Texas and the other states that had this on the books only enforced it against male homosexuals. And so when they were convicted, both of the gentlemen challenged the conviction. And eventually the case made it to the Supreme Court, where the Supreme Court said, listen, we are going to have to examine the constitutionality of going into someone's home and making a moral decision, making a decision about what people do in the privacy of their home based on our own morals. And so they said that homosexual men in this instance were entitled to dignity in their own homes. It's under the right of privacy. And so they won their case. Those laws that were still on the books, mostly across the South, were all declared unconstitutional. So then the question became, is it legal to not allow people that are the same gender to marry? This was codified in the 90s when Bill Clinton was president under the Defense of Marriage Act. Defense of Marriage Act said marriage to us in the federal government is a union between one man and one woman. And we're not going to recognize marriages of the same gender, of two people that are of the same gender, and states don't have to recognize marriages. It's like if it was legal in Massachusetts and a couple moved to Texas, Texas did not have to legally recognize that marriage. In fact, in the Texas Constitution, we had an amendment that said that we would not recognize a union that was legally performed in another state between two people that were the same gender. Now, if you know anything about the United States Constitution, there is a provision in the United States Constitution that says that you have to give full faith and credit to the laws of other states. Somehow, the Defense of Marriage Act just skirted around that amendment and allowed states to do just that. In the United States versus Windsor case, this was not a Texas case. The Supreme Court said the federal government can't do that. The federal government cannot discriminate against people that were legally married in their state. So they knocked down that part of the Defense of Marriage Act for the federal government. So federal government had to start recognizing marriages, allowing people to put their partner, their spouse, on as beneficiaries of on life insurance and health insurance, and had to start recognizing. And then in 2015, the court heard Obergefell versus Hodges. And in Obergefell, the Supreme Court said, listen, if you are telling a certain group of people that you can't do something, but somebody else who is differently situated can do this, then that's a violation of the Equal Protection Clause. So they said that all states had to recognize legal marriages between two people that were the same gender. That they could not discriminate against people that were legally married in other states. Not only could they not discriminate, they had to recognize and allow licenses for same-sex couples as well. Oh, that did not go over very well in several states. It's been a few years now. There was a county clerk in Kentucky that still was refusing to give marriage licenses. And she was put in jail for contempt of court. Her name was Kimberly Davis. It's been a little while. So this chart outlines some of the key struggles and talks about 3 landmark cases. The United States constitutional violation and what the actual violation was. Very useful as a tool. The charts in this book are actually pretty good. So I would invite you to spend a little time looking at these cases. So the only one on here that we didn't discuss is Roe versus Wade. Roe versus Wade is a pretty famous case, but it started in Texas. It was a lady named Norma McCorvey that sued the state of Texas. They gave her a fake name, called her Jane Roe. She sued the district attorney in Dallas County, Henry Wade, and because Texas had outlawed abortion, and that when that case made it to the Supreme Court in 1973, the Supreme Court said that this is an invasion of the privacy of women to make decisions about their own bodies. So Roe versus Wade is another case that actually originated in Texas, and it addressed the right of women to choose. All the rest of the cases we definitely have discussed. So to round this out, let me just finish this discussion with this. Texas has been and is still one of the fastest growing states in the United States. There has been no decade where, when they took the census, Texas did not see at least 10% growth. Texas is becoming, I would argue, has become much more culturally diverse. And And we're starting to see that reflected in um, culture, voter participation. We looked at the beginning of this chapter at the 2018 elections, and we saw that a Democrat came really, really close to defeating a Republican, which is something that would have been unheard of 20 years ago. So this stops, these are census numbers, 2017. And as you see, so this is 1980, this is 2017. The percentage of Anglos has steadily declined, while the percentage of Latinos, as the book likes to has steadily increased. Um, in 2017, 39%. We are in a census year, so we will see all kinds of things are going on, but we'll see if this trend holds. We are expecting people of Mexican, Puerto Rican, really any country in Central or South America or the Caribbean that self-identify as Latino to be 50% within a couple of decades. African Americans have held pretty steady as a percentage. So the numbers, of course, have increased, but the percentages have remained pretty steady, 12, 13%. The actual largest growth in Texas has been Asian Americans, who went from 1% to 5% from 1980 to 2017. So the percentage of growth, the percentage of growth has been much higher with Asian Americans in Texas than even Latino Americans, even though the number is much larger. So Latinos are the largest minority group. The fastest growing minority group are Asian. Let's look at some demographics. So first we're going to talk about income and poverty. So these numbers, I believe, are 2015 or so. And we're looking at the median household income. Notice that the largest median household income is Asian Americans, followed by Anglos, followed by Latinos, and then African Americans median, that's average, is African Americans are the lowest. Now let's look at the percentage of that are living in poverty. Anglos 9%, Asians 11%, African Americans 20%, and Latinos 22%. The amount of people that you have that are living in poverty it reflects many things. So it affects how much money you get in aid. It affects voting numbers, because people that are lower income are less likely to vote. They don't have time. They don't have time to worry about that. It affects your schools. It affects funding. So the percentage of people living in poverty really does have large political implications. So to tie it all up, I'll just say this. There is no more there are no more laws that say that you can't go to a certain school, that you can't live in a certain place. You They used to have restrictive covenants that said you couldn't, if you were white and you lived in a neighborhood, you couldn't sell your property to someone that wasn't white. That's illegal. But we do see that there are still lingering vestiges of Texas's attitude, Texas's history, that permeate many, many things. And so we have very rich school districts. We have very poor school districts. We have neighborhoods that are predominantly African American or predominantly Hispanic or predominantly white. So we are still seeing some of the lingering effects of Texas's history, and it certainly affects the policies. Now, I just went ahead and did this long lecture to go ahead and finish out. This is the end of chapter 1. And once we finish chapter 2, then you will have your quiz.